Kim Perez Rockwood. She has been with us a time or two before, I think, maybe over the years. And she's our go-to person for legal things. As you know, as a home inspector and your interactions with clients and other folks, sometimes, hopefully not, but sometimes legal aspects can arise. We have things called inspection agreements that hopefully will at least lay some of the groundwork for the legal and binding relationship you have with your client. And I'm sure Kim can help speak to that. But Kim is with Rockwood Law, LLC. Her presentation today is what you need to know to keep the lawyers away. She is a graduate of Georgia State University, College of Law. So she's a hometown girl here, I guess. Okay. And she specializes in estate planning and business law. And she has helped numerous contractors, subs, material providers, designers, and inspectors navigate disputes with clients and other businesses. So please give Kim a warm welcome.
Thanks, guys. Can you guys hear me okay? Anybody? I guess if you can't hear me, you're not really going to respond. But, okay. First of all, before I get started, I have some form that I want to pass out. If I can get one volunteer to just go around and pass them out for me. It's a survey that if you guys fill it out for me, it'll just give me some information about how I do today. And also, if you want to schedule a consultation with me, then you can do it for free. It's a $250 value if you have any questions. So if you fill it out, send it back to me. That's it. Yeah, sure, that'd be great. Then I would really appreciate it. Thanks. All right, so good to see some friendly faces in the audience. I'm glad to be back here. I hope that this is worth your while. So let's go ahead and get started. All right. So just to sort of give you an idea of where we're going today. So this is what we're going to do. So first of all, what I'm going to do is talk to you about the law, what you need to know. I'm calling that your toolbox. Those are the tools that you are going to use to keep people like me away. So we're going to do that first. And then to make it a little bit more interactive, we're going to spend the next half of the presentation going through some actual case studies. And a lot of these hypotheticals that you'll see that we'll talk about are from actual Georgia cases. So we'll get into that and we'll talk about how those impact your practice. And then if I know you guys, the Q&A is probably not going to be at the end. It's probably going to be scattered throughout. But I'll also open it up for questions at the end too, just in case you guys have any last minute questions. All right, so let's get started. What types of things do you need to have in your proverbial toolbox to keep the lawyers away? The first, these are the nuts and bolts of what you guys need. You need to have knowledge about your job, which if you weren't here, then I would be worried about you. But you guys kind of have this part locked up, the knowledge part. You also really need a good, solid contract. It's actually required by law. We'll go through that in a second. You need a paper trail. And you need incorporation. When Mike introduced me, I said I was a business lawyer. What I do is real estate related business advisement and stuff like that. So incorporation is a part of that. So I help guys like you make sure that you don't need other lawyers like me. And then insurance. Just out of curiosity, how many of you guys in here are insured? So about half. That's about what I was thinking. Okay. Yeah. Just we'll get into that in a few minutes. But this is just a general overview. Here we go. All right. Quote. First, we're going to talk about the knowledge part of your toolbox. One of my favorite quotes: "The dumbest people I know are those who know it all." By Malcolm X. All right. So as far as knowledge is concerned, first of all, we're going to go through the statutes, the legal statutes in Georgia that pertain to you and your job, and your obligations to your clients as well. We'll also talk about legal precedent, which are the court cases and what they say and how they affect you as well. And then what your contract should say and what your contract obligations are to your clients. And then, of course, we'll talk about how you guys need to know your job and the standards and ethics. We'll get into that. Okay. Here we go. There's a statute in Georgia. It's OCGA 8-3-330, and it goes to 333. And it applies just to you. And what it says is that, well, first of all, let me back up. It applies to home inspectors, private home inspectors, not inspectors hired by the county or any other governmental workers. It applies to inspections that are done in any home or single-family dwelling. And it tells you what must, first of all, it tells you you have to have a written contract, and then it tells you what must be in your written contract. And this is the only profession I've ever worked with where it's an actual misdemeanor not to have a contract and to have the specified things in your contract. Now, I've never actually seen that. I've never seen anybody get in trouble for it, but it is on the books. So, just so you know. All right, some other statutes that you guys should be aware of. Licensing, still not required here, but it is in most of the neighboring states. Alabama, South Carolina, North Carolina, Tennessee.
And Florida.
And Florida, thank you. And then we have a statewide application of the minimum codes. That goes back to 2004. That hasn't changed, obviously. Meaning that, you guys probably already understand what that means, but that the minimum codes require, or even though they may vary, or the codes may vary county to county, the minimum codes apply all throughout the state of Georgia. And then the Right to Repair Act. How many of you guys are familiar with this? It's fairly new. Yeah, Peter thought it would be. It's fairly new. I say fairly new in the eyes of the law. That's 2009. That's pretty new in the eyes of the law. The law moves really slowly. The Right to Repair Act came about the time that builders were required to be licensed in the state, which was also 2009. And what it does is it provides a framework for consumers, if they're having trouble with a contractor or their home builder, they have to follow a very specific set of procedures before they can actually file a lawsuit. And there's a reason it's called Right to Repair, because one of the hallmarks of that statute is that the contractor or builder has the right to come back and say, I choose to, rather than get sued, I choose to come back out and try to make it right, and try to fix what's wrong. Now, just speculating here, can you guys imagine, how do the consumers react to that, do you think?
Not very well.
Not good, that's right. Most consumers, by the time they come to see a lawyer, they've already had it up to here. And when I sit there and I tell them that the builder under this statute, there's the site for it, 8235, that our legislature decided that the builders have a right to come back out and not only be on their property again, which most of them are not happy about that, but also to come back out and try to fix again. All of them tell me, well, they're just going to screw it up. I don't want that guy anywhere near my house. Well, nothing I can do. My hands are tied. But part of that statute, I'll get to you just in 1 second. Part of that statute, though, too, is that once the work is done, then they have the right to have somebody come out and inspect it to make sure that it's been done correctly. That's why I bring it up to you guys, because there may be a time where you are called in a situation like that. Question?
That minimum code, item number 2, what is that? Is that an IRC code or is that a state?
These are state codes. They're Georgia statutes. So if you...
OCGA stands for the official code of Georgia. That's
Yeah.
like
Right,
Right.
but is that code written? Okay.
We use the word code interchangeably with statute, which is
Oh.
basically just the set of written laws. So
Okay. It's not a building code.
that's correct. That's correct. It's not. Yeah. Any other questions about this slide? Okay. All right. So those were the statutes or legal codes that pertain to you. Now we're going to get into, there's a whole other body of law. Yeah, quick question. Sure.
I'm sorry, Kim, I did have a question on the last one.
Okay.
You were saying that if the contractor comes back and repairs something in my house, then I have a right as a consumer to have it inspected?
That's correct.
Okay.
Yes, so the way it kind of makes the consumers feel a little bit better about the process. And then there are a whole bunch of other steps that happen afterwards, and it's not done properly, and notice requirements and stuff. If you have questions about it, then, call me, but it's too much to go into today. Yeah, question?
It's not required that home inspectors be licensed in Georgia.
That's correct.
Can I go to Alabama, South Carolina, and inspect homes?
Not unless you have a license there.
I did go to South Carolina.
Don't tell anybody.
Yeah.
We also have in our pre-inspection agreement the right to repair if somebody has a conflict with us.
No.
No?
The reason is because, well, there are a lot of other tools you can use that are better.
Okay, good.
And we'll get into that in a few minutes. Yes, you guys we do have some better tools for you, specifically for you and your profession. Okay, so these are law is weird. We have a whole set of laws we have to follow that's codified and written in a bunch of these big, thick books. Now it's mostly online, but I think they still make the books. I don't know any lawyer that uses them anymore. But the big books, okay? And then we also have a whole other set of laws that we're supposed to follow that are just cases that the courts come down with. And that's what we call legal precedent. And so even though most of the legal precedent is not ever codified and written down into code form, it's still just as valid. And so these are some of the situations that have come out of legal precedent that you guys also should be aware of. The first one is something called limited liability. And this is a clause that I'm going to talk about in just a little bit that I recommend you put in your contracts. This is one of those situations that addresses your question. It's very helpful, and the courts have actually upheld it and said, yes, that's valid, you can do that. Okay? It's very helpful, but it shields you from liability, or in a way, it limits your liability if you were to ever be exposed to any. But it also, just so you know, it's a little bit nuanced. It doesn't mean that you don't have liability at all, and it also means that there's no loss to you, but it is limited in certain scope and form. And we'll talk about that. I'll show you some examples in just 1 second. It's just an overview of the legal precedent. Legal precedent has also made, or the cases, in other words, also made a distinction between negligence and gross negligence. If you are ever found guilty of negligence, or guilty is a criminal law term, but if you're found liable of negligence, then the limited liability clause in your contract will kick in. So in other words, if you overlooked something and it was something, I'm just trying to say, I can't think of an exact example right now, but something that a lot of inspectors may overlook, or just fail to put in your report, then most likely what's going to happen, that's just simple negligence, a mistake that you made, okay? And most likely the limited liability clause is going to kick in, and your liability is going to be limited to the amount that the client paid for the inspection. That's usually what happens, okay? But gross negligence, the distinction is, gross negligence is something that no inspector would have made that mistake. It may have been a mistake for you, but it was so careless that the court says, okay, that's beyond just simple negligence, that's more than a simple mistake, therefore you should be held responsible for that. That is not going to be, gross negligence will not be covered by a limited liability clause. You guys are so well educated, you stay on top of your job. I've never seen any inspector, I've been practicing now for 16 years, I've never seen any inspector that had trouble with gross negligence who was a member of GAHI. Putting that caveat out there. I've seen some of them, but none of them that were members of GAHI. So yay, good job, good job. So you guys are the creme de la creme of your profession. And then the case law also says that even if it's not written into your contract that you have a duty to perform your job to the best of your ability, then the law reads it in anyway. So that's what's called breach of a duty. Usually just means that you had a duty to perform to the best of your ability and you didn't do it. That you can still be held liable for And then a lot of these cases where people come to me are a failure to get paid. How many of you guys have had a client stick you on your feet before, ever in your career? Yeah, exactly. So a lot of these cases come down to a failure to get paid too. All right. Okay, your contract. So how many of you here have an inspection agreement? Okay. All right. So if you do, which you should because it's required, we can talk afterwards if you don't have one. You need to know exactly what your contract says. You need to understand all the verbiage. Sometimes I know a lot of people I know, a lot of inspectors included, but other professions as well. They find, especially now with the internet, they find a contract online, or they go to Office Depot, even if they're, even if it's a rental property or something. They go to Office Depot and they just purchase a contract and they say, here, sign it, and they think everything's fine. The problem is, you don't, without understanding what it is that you're agreeing to, you could get yourself in some trouble. What you've agreed, know what your contract actually says and what it means and what the implications could be of the language in it. And if that requires setting up a 1-hour meeting with a lawyer, and that may cost you $200, that is $200 well spent. Because if you get sued for a breach of doing something, you're going to spend way more than $200. Quick question. Yes?
Is the requirement for the agreement a Georgia mandated law for our occupation, or is it just to protect us from lawsuits and a way of getting paid?
It is mandated law for your profession, and honestly, my opinion, it's to protect the public from you. That's why it's a misdemeanor if you don't follow
The
the
state
law.
of Georgia requires us, because of our profession, to have an agreement that has to be signed.
That is correct, yes. Yes, that is correct. And your profession, with technology always moves faster than the law, always, always, always. You can quote me on that every day of the week and twice on Sunday. So the issues that I'm finding most recently with you guys are the issues of software and sending your agreement out electronically. And we're going to get into that in a few minutes too, and we're going to talk about some of the case studies and real world examples and talk about how to solve those problems. Did you have a question about that?
Yes, no matter how well our contract is when if that contract is signed after the inspection starts, or before the inspection starts, have an effect on its execution.
Yes. Did you have an answer over here? Yes. You need it signed before the inspection starts, because otherwise it's not going to be effective. When a contract is signed and executed by both parties, that's called the binding agreement, or it's called the binding agreement, and then it becomes legally enforceable. If you wait and have it signed after the fact, it's probably not going to be legally enforceable. So you need to get it done beforehand. Yes. Okay. Moving on again about contracts. Privity is a legal term that means that when you have a contract with somebody else, that means that you are both in privity of contract with each other. Privity means first degree, I guess. The first degree. Okay, so what happens sometimes with you guys in your profession is you do an inspection, say, for a pre-sale situation. And you provide your report to the seller of the home. Well, say the buyer comes along, the buyer's like, oh, it's fine, they just had an inspection done. I saw it when I went to the open house, it was sitting on the table along with the disclosure statement. I don't need to get my own inspector. So what happens all of a sudden is the buyer relies on what your report says in making their buying decision, right? But what that also comes with that is a situation where the buyer's a third party, the buyer's not in privity of contract with you. That makes it harder for the buyer to rely on the statements that you've made, and you can protect yourself in that situation by having your contract.
The contract was with you and
That's correct.
not the buyer.
That's right. That's right. But the buyers will use it. The buyers will use it to rely on. There's some cases about that. There's one in the case study I'm going to show you. Trespasser. This doesn't come up that much anymore because the real estate contracts say whenever seller and purchaser enter into a binding contract to purchase a home, that contract says that the home inspector is coming onto the property to inspect the home, and we both agree that he or she is not going to be a trespasser. So that kind of is taken, that's not so much of an issue anymore. It used to be back in the day. Yes?
How, does that give the owner of the property legal notice that you're gonna be there so that if you don't get paid, you can file a lien against the property? Is that effective legal notice?
Yes.
That, okay.
Yes, I would say yes. Absolutely, yeah. Because it's not just notice. They actually have a contractual obligation to allow you onto the property. But it's obviously for a limited time. It's just for that inspection period. I mean, clearly, yeah. Question?
Sorry to worry this point, but I've been doing a lot more pre-sale inspections because people want top dollar in a hot market. They don't want the next inspection to kick it out. And you've been asked to answer to me, the way I understand it is, if I provided an inspection report to that seller, they are now liable to disclose everything on that report to anybody who comes down the line, obviously any potential purchaser. And they therefore hold liability for repair or non-repair of the items. Could you clarify that for us, so we know what to tell our pre-sale clients, you know?
Yes.
And they don't, a lot of them don't want to do it for that, for the liability.
That's a good point. Did you guys all hear that question? That's an important question. So in a resale situation, when you provide the inspection report for the seller of the home, the seller is required to disclose at that point what they know about the home, even if usually it's bad, right? They're not going to disclose, well, they're happy to disclose great things. So yes, you're right, a lot of sellers, I would say it's probably about half and half these days, just on my estimate. I could be wrong. You guys are out there in the field every day. I would say about half sellers will do a pre-inspection and half won't, because they don't want to know what's wrong with their house. Because, in the past when I did a lot of this litigation, then I would tell my clients, you have to disclose what's been done. Otherwise, you could get sued for fraud. And that's really bad. Fraud is bad, because fraud means double and triple damages sometimes. So, and also it means your insurance and your homeowner's insurance won't cover you usually. So you have to disclose what your inspector found. But you're right, what it does is it shifts the liability from you to the client, to your client, to the seller. So usually that won't come after you, but yeah, question.
Okay, so that property and the obligation to the homeowner, does that give them the right to try to sue you because they perceive the inspection report as evaluating their home, and they want to recover that loss, financial loss, from your inspection?
Usually no, there's no, I can't think of a conceivable legal theory where they can sue you for disclosing what's actually in the house. Yeah, oh, well, that's true. Doesn't mean that people won't try. Some people will try if they're really unhappy, but if you don't have a strong legal theory, you're not going to get very far. A good lawyer would say, you don't have a case, I know you're mad, but you just need to fix whatever's wrong or discount the price of the home, or there are other legal ways to deal with that. But you're right, anybody, you can go file a suit against anybody for any reason. Doesn't mean, though, that it's going to fly. Still makes your life a little bit difficult for a short period of time. That's just the way our system works, unfortunately. Yeah?
If you do an inspection for a purchaser, inspection turns out bad, the purchaser walks,
Yes.
does the homeowner then have the obligation to make that information?
Yes. Well, not that the purchaser walked, but the homeowner still has the obligation. The homeowner still has the obligation to disclose what was found, even if it was the purchaser's inspection.
Only if you got a copy of the report.
That's true. Only if he knows. That's true. He may not know.
That's what I was going to say.
Yes.
The realtor stands in front of that.
That's right. That's exactly right. A lot of realtors probably won't let that happen.
They don't want to know. I don't want to see the report if you're walking.
Yeah.
I don't want the report.
You get that. You get people telling you.
So let me just tell you, let me just give you an example of how it plays out down the road. So, so what would happen in that situation is, and just for your knowledge, so you can kind of understand how it would, like I said, play out. So the purchaser says, "Oh, there's too much in here. I don't want to. I'm not comfortable with this anymore, and I'm not willing to put that much money into fixing it. So I'm going to walk on the contract." So, and then somebody else, okay, but the seller has no idea. The seller just knows. Well, there is usually an absolute right to breach after, to abandon the deal after the inspection. They usually can do that anyway. The seller doesn't always know what happened. Question? Yeah.
When the seller knows, because another contract says, continue on the home inspection. So if someone said, I might buy your house to the home inspection,
The seller would, right.
give a copy to the seller so they know that, okay, these are the reasons he's walking.
Usually the seller will know, but not always the specifics. So what would happen down the road is if another buyer comes along and says, "Oh, I noticed the price was reduced," the seller says, "Well, the last purchaser wasn't happy with the amount of work that had to be done." That doesn't necessarily mean anything bad was wrong, right? It doesn't mean that they were hiding anything really terrible. The purchaser just changed his mind, wasn't happy about having to make more changes, or that's all the seller knows at that point. It's not fraud. Now, if the seller knows, oh, there's a leaky basement, and I didn't know about it till just now, and the seller goes on with the subsequent purchaser and doesn't disclose that, and the purchaser then buys the house and finds out after the fact, and can tie that and can find a paper trail going back to where it's to proving that the seller knew about it, then that seller's in trouble. But it's all of those steps. And then you have to prove with a paper trail, and it's a long, tedious process. Yeah. Question?
Home getting software, not going to use it. And any time that report is sent to someone, I know that they opened it, and I know.
Yeah.
how
Oh, right.
the whole
Stop.
road.
Right.
So,
Right.
so they,
Important. I'm also going to talk about that too. So that's good. That's another one of these good tools. There's a contract provision you can put in to prevent all this from happening. Yes.
Water forms, which they keep changing every
Right.
for the last 3 years.
Right.
Okay, only ask that the property been inspected.
Yes.
Yes or no. Okay? There's a big company in town who, under no circumstances, do they want to receive a copy of the inspection report. Okay?
Yep.
So therefore, then if they don't know about it, they don't update the seller's disclosure to indicate it's been, okay, so that's outside of our realm. But the person who pays me owns that inspection, and I can't release it
Right.
unless I have a release from the person who paid it.
Yes. So that protects you. That's a very good tool to have, and I'm going to show you what language you should put in your contract that will protect you in a situation like that. Another question?
Just a comment is,
Yeah.
experienced real estate agents understand all of this.
Yes.
And the two agents don't like each other. One, they can disclose it, and, they choose to not or do it. So we're kind of on the outside, but all these mechanics of the deal are all playing out, and we just don't want to get dragged into it, right?
Yes, absolutely. So
That
you
be your
wanna-
legal advice?
That would definitely be my legal advice. Don't get dragged into it, and make sure you protect yourself with a good, solid contract that will shield you from a lot of this stuff right up front. So before I get into the nitty-gritty of contracts, which I'm about to do after this slide, the last thing is, obviously you need to, again, I'm saying this to you guys, it's like preaching to the choir here, but obviously, you need to make sure that you're on top of your industry at all times as far as knowledge. You guys need to, do like you're doing now, go to trade association meetings, get all the education you get. If you have got other home inspectors that you hang out with and can bounce ideas off of, all of that helps to prevent you from getting sued. All right, let's talk about the nitty-gritty of contracts. This is kind of the meat of it, the meat of the presentation. Another witty quote: "There's nothing more likely to start disagreement among people or countries than disagreements," by E.B. White. Okay, this is what's legally required under the Georgia law. One, not only that you must have a contract, but two, it must have all these three things in it. You have to have a description of the scope of your inspection, and GAHI has one. You can use GAHI's scope. Ashley has one as well. But you must have a description of the scope. You must have a statement that the inspection is a visual inspection. Now that actually, what do you guys think? Does that protect the consumer or you? Yes. So there you go. You got a bone there in the statute. Okay. So you must say that it's a visual inspection. Yes.
Visual and accessible.
Yes. That's yes. I think it's good to add that in your contract, exactly, but all that's required by the statute is visual, but accessible helps you. So this is the bare bones, so this is the floor of what must be in your contract, but what you should do, and I'm going to talk about that in just a second, is add layers and layers of other things on top of that floor to protect you, because you can, and you should. And then,
Question on that.
sure.
When we say visual,
Yep.
and then we start using infrared equipment,
Yep.
how does that play into the visual part? Then we'll see things that are not visual.
That's fine. The answer is, it doesn't. The answer is, you might do that, you're providing an extra service to your client, but all you're agreeing to be liable for is what you can see visually. So you might do that, but this is all you're required to do. Does that make sense? That's a very lawyer response, right?
If you do that,
Yeah.
do that, are you going beyond the scope of what your agreement is stating?
Now, that's correct. If you do that, you're going beyond the scope of what your agreement says. However, if you do it, you can't, you need to know what you're doing. You need to still not make mistakes. You need to not commit negligence if you're going to go above and beyond, okay? So you still have to do all that. You still have to do a good job, right? But all you're required by law is to say it's a visual inspection and do a visual inspection.
If you're using those type of terms, if you put in your agreement that those are used only to help enhance the knowledge, but not to expand the scope of the inspection, you should be fine.
Absolutely, yes. If you put in your agreement, it's a visual inspection. But we may use other tools to help, expand your knowledge about the situation that, the house, whatever the situation is. Then yes, what you're saying essentially is, this is for you, I'm doing this as a service for you. If you provide extra service, it makes you more competitive in the industry. So you do it as an extra service for the client, but, use at your own risk, client. It's for your own knowledge. Expand the scope.
But really, the main reason you're using that tool is to give you more knowledge, not necessarily the client.
Sure, that too, yeah. But just know, this is the floor. This is what Georgia says has to be in your contract. And then the last thing is a statement that you'll notify the client of the defects in writing, a report, and recommend that certain experts be retained to determine the extent and corrective action for the defects. You guys do that anyway. That's pretty much what your job is. But you do have to have this statement in your contract. Okay, again, just stressing that it's a misdemeanor. I just find it so fascinating that for some reason you guys are singled out. That like I said, yeah, you read that correctly. Anyway, blows my mind. Yeah.
I've got a question. Now, all my agreements, language, are going to be kept e-signed.
Yes.
Back in, I've got some back past years, where I would do either electronic or custom sign. I get a job site, I get signed at a job site. I had cases for the custom call, I can make it. And so I didn't get signed before, but I sent the agreement to the sign before I could get home, even though I started home before. So
Special section, just the way the inspectors.
I was given back the report.
Until they sign it? So what you're saying is,
But they didn't show up for, they said I was going to be there.
that happens a lot, right?
And it
And they-
doesn't work manager, the way it pans out.
Yeah.
So I've got some in the past that I got agreements signed before the air was to get home inspection.
Okay,
But
that's fine.
they didn't show up.
Yeah, so what you're saying is, what you've done, or what you do now is you send the contract out before the inspection, and the client signs it, but they don't come to the
That's why
inspection.
they put a money there, so they want easy.
That's what you should do. Yes, that's exactly the right thing to do.
But in the old days, I had some that,
Yes.
I did it both ways, and I did like a either, I just bought a hard copy and signed it and show up there. I would then send them an email copy, get it signed before I release the report.
Yeah. Okay, so what you're saying is if you have the old-fashioned way, if you have a hard copy contract, you show up at the inspection and you tell them that they need to, or maybe they don't sign it there because they aren't there, but you tell them they need to sign it before you release the report.
Right.
That may or may, well, like you said, it's the old way.
Right.
There are better ways now. I would still fight, if I were the lawyer for the other side, I would still say that was not an enforceable contract because you guys didn't, it wasn't signed before the inspection began. So, too bad.
In light of what he said,
Yeah,
the old way,
the old way, yes.
you send an email
Uh-huh,
for confirmation of the inspection. And
Right.
attached to the email is the contract.
okay.
And they respond and says, yes, I got your email, blah, 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 I will be at the inspection to sign the contract. When they respond to the email, is that not an agreement?
Nope, not an agreement.
Even if they state they agree in the use.
I would say that's not correct. I would say that's.
Verbal contract.
I've been on both sides of these cases. If I were your lawyer, I would say, that makes me really nervous that maybe we have an argument. Because we don't really, but if you say yes to the email, it could be construed as what? They said yes to being, they said yes, I agree, but did they agree to all the terms of the contract? Did they agree to being there? It's too ambiguous. Whereas if they actually sign, then we know, then we know what they've agreed to do.
Send that out. This is the way I do it, because a lot of people don't have any way to print it off and scan it back, so.
Right.
I say you need to sign it, or send it back, or reply directly to this email with the following statement. I have read, understand, and accept all terms and conditions of the agreement. They reply back to me, I've got that, plus the agreement is on that email as returned. So
That would work. If you're that
Like a software-
specific,
like a software.
yes.
Yeah.
If you're that specific, if I were your lawyer, I would say, open a check case. And if I were the other side's lawyer, I'd say, I would say probably the flip side. I'd probably say, maybe we have an argument, but it's weaker. It's a lot weaker. A lot about law is, it's all gray area, folks. Well, that's not true.
What would happen if you post-dated?
Mostly gray.
What would happen if you post-dated but you did sign that agreement? Where we have the report, we did the inspection following day, and you say, listen, you need to date that from the day prior to the inspection, or whatever the case may be. How would that?
If you post-date, okay, the question is, what happens if you give the contract, if you have a contract, and you sign it after the fact, but post-date it? Predate it, thank you, yeah, predate it. So you go back and you date it the day that,
Of
of the inspection, okay? That may work. The reason I say may is, well, I still think it's too ambiguous. I think the best thing, easiest thing to do is just get it done that day. Of course, I realize that this is real life, and things happen, and it doesn't always happen, it doesn't always work out that way. If you predate it, it may work. It may work. But there's an argument to be made, and I'm going to show you guys a case that came out just about a year ago. It was March 17th of last year, so about a year ago, where it was a situation like that, and the court said, there might be a reason here to fight the contract. It's only hands.
Okay, guys, let's sort of get through her content, okay, because we'll be here all day, all right? And let her do what she needs to do, okay? Like when you're on an inspection, you want your client to let you do what you do. Let her do what she does, and then I'm sure she'll be more than happy
Yes.
to stay later, okay? But look, dude, we got more speakers we got to get here, and you're going to get hungry in a minute, okay? So let her do what she needs to do, and then,
It's hard. It's hard. I agree, she don't have a
Do you,
Do you need me to have?
you want her to have a lot of everything?
Yes.
Yes, okay. Sure, no problem.
There's supposed to be a lot of everything that you got here.
Oh, is that, okay, sure.
Let's see what this does. How about that? Great. You can attach that somewhere.
Thank you. All right, can you guys hear me? Is that better? All right, excellent.
Whoa,
For now, I can hear myself better.
now away.
Okay, back to the contract. This is, again, like I just said, you guys are required to have a statement about your scope. And I just put this up here for reference, you guys know, but this is perfectly fine. Have a statement about the scope straight from the GAHI website. Okay, next. Okay, this is the section where I told you that the statute just is the floor for what must be in your contract, but there are a whole bunch of other tools, a bunch of other layers that you can put on top of it that will help you. And these are the things I recommend. This is what should be in your contract. A limited liability clause, and there are two different kinds. We'll go to that in a second. A reference to the standards, not a code inspection provision, an attorney's fees provision, a confidentiality clause that gets at the issue of third parties using your report, a complete agreement clause, which also gets at the issue of third parties. So I'm going to show you an example of every single one of these things. And then a jurisdiction and venue statement. And if you guys want a copy of these slides, just send me an email. I'll give you my information at the end, and I'm happy to email you this entire presentation if you want. But in the interest of moving forward, all right. One of the types of limited liability clauses you can have is a limitation on damages. You really, 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 really should have this in your contract. Really, really. And the main reason is because it's specifically been found in the Georgia court cases to be enforceable. So if you say this, and this is exactly the verbiage that I would recommend you put in your contract. Client agrees that the inspector or any of his agents or employees shall be found liable, blah, 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 including but not limited to, typical lawyer language, right? Here's the important part. The inspector shall be limited to the sum of the inspection fee paid by the client. So if a client calls you and says, really unhappy about what you found in that inspection report, I'm going to sue you, you say, how about I give you your $300 back? And that's all you're required to do if you have this in your contract. Very, very important. The other type of limitation on your liability can be a limitation on time. This is the one that is most common, a 1-year limitation on your liability. And that's all you need to have. It's just one simple sentence. And it can be in addition to, these are not exclusive of each other. You should have a limitation on the amount of damages and a limitation on the time. So liability is limited to 1 year from the date of the inspection, period. Now, so it may be enforceable. It's been enforceable thus far in cases. However, there are a lot of employment contract situations, a lot of cases about employment contracts where, with restrictions on employment, where the employer says you can't go anywhere else and work within a certain mile radius in a certain period of time. Usually in those cases, 2 years is about the maximum you can do. For you guys, the 1 year is still enforceable, but I'm just saying that if it leaks over one day, that whole body of law, 2 years may be the most, or the least amount that you can do. Does that make sense? You might only be able to limit your liability for 2 years as opposed to 1, so it works less favorable for you. But for now, 1 year is still enforceable, still the law. All right. Also recommend you have a not a code inspection clause.
Kim, can I ask a question?
Sure.
So you limit yourself to saying that you're not going to cite code. Now, obviously, as as inspectors doing new construction,
Yeah.
code is one of the most common things that you're referring to because you're
Yes,
also
it is.
working with a builder. But when you're dealing with a resale situation, if you start citing a code, if you don't cite a code on something but cite a code on something else, can you have an issue or a problem? Because all of a sudden you've changed the format. You're saying
Right.
you're not going to cite code, but now you are citing a code.
The answer is it probably isn't the best practice because it probably could open you up to some liability. But in reality, I've never seen that work out. I've never seen you get held responsible for citing code in one part and not in the other.
Usually the challenge comes back from the seller.
Yes.
If you're citing something and, they want to have some element of proof
Right.
that what you're saying has validity.
Yes, that's right, that's right. And the other thing, the other thing too is, it kind of goes back to our earlier conversation of, I'm providing a better service by, by citing some of the codes, but I'm not really, but at the same time, under your contract, this is not an inspection for
A
code
focused
compliance.
code inspection.
Right. So why I say put it in there, because on the face, it's going to protect you. It's an additional barrier for liability. Just put it in there anyway. All right, the attorney's fees provision. You have your choice here. You can do one of three things. These are exclusive. You can't do all of them. You have to pick one. You can either say that the client bears all costs in the event that you get sued. You can say that the loser bears all costs, or you can say the parties bear their own costs. This is just a matter of personal preference. A lot of business owners will say that the client or the consumer bears the cost, and that's really just to prevent the consumer from suing. It's kind of an incentive not to sue. So that's really probably the most common clause. But you should have, I think you should still have an attorney's fees provision in there anyway. Confidentiality clause, again, this also goes to protecting you against third parties. And here's an exact example of what it looks like. The inspection report is prepared exclusively for the client. The inspector accepts no responsibility if the report is used by third parties. Now, the issue here is, what does used mean? And it hasn't been interpreted by the courts, but just be aware that somebody may come up with that argument later. Depends on how they use it. Yeah, question.
What about if you put a clause in that says that plaintiff and defender, that the plaintiff bears all the costs?
Yep, you can do that.
Okay.
Say that, yes, the other side bears all the costs. You can do that. Usually, though, it's only enforceable if they win. Anyway, again, the confidentiality clause is just another tool to limit your liability. The complete agreement clause also limits your liability. What it says, this is important, this is in almost every contract that you sign too, by the way. It says that your agreement is limited to exactly what's in the contract itself. So if you say something, you're having a discussion with your clients, and you say, oh yeah, I'm trying to think of an example, but I can't think of one right off my head. Although I know I have one in the case studies we're about to go through. But if you say something and they rely upon that, but you don't have it written in your contract, then they can't sue you on that. So they can only sue you if there are terms in the contract that they agreed to. Another reason why you want to make sure that your contract is signed beforehand. Otherwise, that's actually a really good point I'm going to say again. If you do not get your contract signed before the inspection begins, none of this matters. So it's all of this stuff that I'm telling you that's going to help you, it all goes out the window if you don't have your client signed beforehand.
So anything you say can and will be used against
That's correct. And so think about it. If you have a limited liability clause, which is my favorite clause for home inspectors, and you have that in your contract, but you don't get the client to sign it, you can't just pick up the phone and say, hey, I'll give you $300 back, that's all I'm required to do. You can't do that anymore. Then you open yourself up to all kinds of stuff. You open yourself up to thousands of dollars potentially worth of repairs that might need to be made.
Very good.
Yeah. Okay. Complete agreement. Jurisdiction and venue. This, we're going to talk about arbitration for a second. You also will almost always see a jurisdiction and venue clause in pretty much any consumer contract you sign as well. And it's really, my bad. All right, I'm just going to hold it. I'm really like not a very coordinated person, so it's hard for me to do 3 things here at one time. Anyway, so what this does is it provides convenience for you. So what you're saying is, if you, hey client, say I have to go to Jefferson, Georgia this afternoon to see my daughter playing a soccer game. I don't know exactly where it is, but I know it's far away. So if I have to go, if I am going to, say I'm a home inspector and I'm going up to Jefferson to do a home inspection, but I live in DeKalb County, if I have that choice, do I want that, and do I want to get sued up in Jefferson because that's where I inspected the home, or do I want to get sued in DeKalb where I live? Exactly. You want to get sued where it's most convenient for you. Hopefully you don't get sued at all, but if you do, that's what this is. So you have that option of putting that in your contract. You also have the option to choose arbitration if you want. And okay, I'm sorry, just back me up. Here's an example exactly of what the jurisdiction statement looks like. Okay, we're going to get into arbitration. What you may want to include in your contract is a list of exclusions. You may want to, and the jury's kind of still out on whether it's the best thing or not. And then an arbitration clause. I have gone back and forth through the years. Let me just put this on my lapel here so it's easier. About arbitration. And the reason for that is because it has turned into, can you guys hear me okay?
Yeah.
Okay. The reason I've gone back and forth on arbitration is because it turned into something, I think, in practice that people didn't expect it to when it first came out. First came out and it was a selling point. First of all, how many of you here have actually participated in an arbitration before? Okay, about a quarter. What about mediation? Have any of you guys participated in mediation before? Okay. Yes, yes. So together, these two things are what they call ADR, alternative dispute resolution. They are alternative methods for resolving a dispute before going to court, or in lieu of going to court. And so the difference between arbitration and mediation. Arbitration is almost like court in that you go before somebody who makes a decision for you, an arbitrator or a panel of arbitrators. You get to present evidence, but you're not in a courtroom. You're usually in a conference room, and you're sitting at a table. You can still call in witnesses to come sit down and testify. You can present paperwork to prove your case. And then at the end of the presentation, usually actually it's not right at the end, but the arbitrators will take some time and issue a written decision and send it to you a few days later. And it's usually not subject to overrule. So usually whatever the arbitrator decides goes. The reason it's sort of, well, I'll get into that in a second. So that's arbitration in a nutshell. Mediation, however, way better, as Bob said. Mediation is it's also a proceeding. They're both private, confidential proceeding. And you come into a conference room, you sit on opposite sides of a table, and you work it out on your own with the help of a trained facilitator. So if you've ever gone through a divorce, you may have had to go to mediation. That's what this is, but it's for the construction world. The best thing about mediation is it's still binding, but you decide whether or not you want to agree. And if you can't get anywhere in negotiating with the other side, you just simply get up and leave. No harm done. It's a much better. Yes, question?
One quick question, and it's about another area where and it's not on this legal matter, but
Okay.
it's something that we deal with, and I know your time's running out. We have after we do our report, submit it to the thing, then they bring a tradesman out just in order to, they're interested in doing some work on their house or something like that. And the tradesman comes out and he has a report and he's trying to sell them, make his job big, you know, instead of small, you know, make his job big. And then he makes a statement like, well, the inspector should have caught this. And then he brings the inspector in. So now then he's got conflict with with our report.
Yeah.
So that brings up a whole list of things, and then of what may be. So they come back to our client, comes back to us, and then says, well, why didn't you catch that? Why is this all of a sudden I'm having to deal with this now? And look what it's costing me, blah, 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 blah. So I'm saying that if that happens in my report, I like to clause it. If that happens, please contact the tradesman.
Yes.
Set up a meeting between you and the tradesman and the client. Prior to him, they're giving him approval to do any work.
Okay.
Okay, and resolve it at that time.
Sounds good.
Because if he's gonna conflict with my report,
Yeah.
then I want to know what is it he's seeing and exactly, you know, and I've saved myself a whole lot of grief because I was willing to do that. And I don't charge for that.
Yes, absolutely. That's a form of mediation. It's an informal mediation, but that's what it is essentially. It's so much, it's better. It's just, I can't even tell you how great mediation is. But you also have to have two parties who are willing to compromise. Sometimes somebody's so mad they can't see straight, they're not thinking logically, and mediation is not going to work in that case. Arbitration, this is what I said, ended up as a good idea, but in practice, maybe not so much. In my experience, it greatly favors the owners, the business owners, rather than the consumers. So, you know, whatever, take that, you guys are the business owners, that's a good thing for you then. The difference is between arbitration and court is the same, well, the same thing is that somebody else is making a decision for you, unlike mediation. But the difference is you don't have the rules of evidence to play, which means that there might be some evidence that, you know, hearsay, for instance, you know. Some evidence might get in that wouldn't get in, it wouldn't be fair, and wouldn't get in a court process. So that's the biggest difference there. And other than that, here, you can see my list here. So the pros, it is a lot faster than court. It takes, if you're right now in Fulton or DeKalb County, you file a lawsuit Monday, you're not looking at a hearing probably for 2 years. So arbitration, we're talking probably a few months. So it's much faster. It's generally cheaper, really, because it's faster. Because you're not hiring a lawyer for 2 years, you're only hiring a lawyer for 6 months or whatever. So it ends up being cheaper generally, not all the time, depending on how much work needs to be done. It is confidential, though. This is the biggest reason why businesses like it. They don't want other people to know that they've had a dispute with a client. And this is all private record. It's not filed in court. It's all private, confidential. And it's less formal. Cons of arbitration, less formal. Less formal meaning you can come in and say what you want. Con is you come in and say what you want, but that might not have been admissible in court, which may not be really fair. It is extremely difficult to appeal because the court system is so backed up. If a judge says, oh, they decided to arbitrate this case, well, I'm leaving it up to them. I'm not going to, even if you don't like the outcome, the judge says, well, that's what you agreed to. Go on about your merry way. You can't, it's very, very, very difficult to appeal it. You're at the mercy of the arbitrator. A lot of these arbitrators are former contractors. And it requires an extra step to collect a judgment. So if you do get a judgment in your favor, it's just worth the piece of paper it's written on. Then what you have to do is go file that with the court. So the court still doesn't know what took place in the hearing. All they know is that you won arbitration, and then you have to go through a collection process. And you would go through the collection process anyway if you were in court. So it's just an extra step. All right, final word on contracts. This is what, and we've actually kind of hit this to death here. So this is the biggest issue right now, I think, facing your industry is the advent of technology and software and how it's affected the way you deliver your contracts to your clients. Anyway, we've kind of talked about this already. The most important thing is make sure that you get it signed beforehand if at all possible. Do everything you can. And if you need to blame me, say, oh, my lawyer says, this lawyer I heard talk, I'm sorry, my hands are tied, I have to get you signed. Okay. Paper trail, we'll go through this really quickly. I actually kind of really like this quote because it describes me fairly well in my middle age here. I'll write everything down I want to remember. That way, instead of spending time trying to remember what I wrote down, I spend time looking for the paper I wrote down. All right. Yes, good question.
I'm using Adobe Sign Now.
Okay.
Most
Yes.
times, the street folks buy a house. As long as we got one signature on that, it doesn't matter.
As long as you have one signature on it, what you've done is you bound that one person to the contract, not to the other one. To the contract, not to the sale of the house, obviously. If there are two people buying the sale of the house.
So you're saying that one person can sue me because I...
Yes, that's correct. Yep. Paper trail, pretty obvious. The more paper you have, the better off you're going to be able to defend yourself. That's just all there is to it. The more paper you have, the better off you are. Corporation. How many of you guys here are incorporated? Oh, good. Most of you. So you should incorporate because it's obviously it's an extra layer of liability protection. What entity you should talk to a lawyer or an accountant sometimes. They can talk to you about the tax ramifications of incorporation. LLCs are a great choice for solos because they have the liability protection as well as tax protection as well. What will be involved? Simple paperwork, but you also need to maintain your corporate minutes every year. What that means, if you're a solo, is you have to write down something every year saying, I met with myself and I made the following decisions. And that keeps your corporation legal and valid, right? It's weird, but that's the way it is. There is a case, and I showed this at the last presentation I did for you guys several years ago, and it still hasn't been overruled. But there is one case in Georgia that says if you're a solo business owner, and obviously if you're the sole business owner, you're going to be the one doing the work. But if you're the one, if you supervise, participate, or direct that work be done, then a plaintiff can what's called pierce the corporate veil, which means get through that liability protection and sue you individually. This is done, I guess it hasn't been applied yet in the home inspector business. It was a contractor case, a builder case.
What is considered work to be done? Is that the inspection or is that other things?
All of it. The inspection, the maintaining your accounting records, everything that you would do as part of the business.
Then what's the point in being incorporated?
Well, that's what I said, is this hasn't, well, it does make it harder. It makes it harder for you to get sued. But like I said, this is just one case that's been applied for building contractors. It has not been extended to home inspectors. So I would still recommend, until this tells me that home inspectors are subject to this, it's still best to incorporate. Yes? Yes?
Fortunately, I haven't consumed very often.
Good. Yeah.
There were two suits. One was against me, the other was against my corporation.
Yes.
So it didn't make any difference.
Well, what happens is, Bob just said, what's happened to him before is he gets sued, one in his individual capacity, and two, his corporation gets sued. Again, now remember what I said earlier about anybody can sue anybody for anything? You could go file a lawsuit tomorrow against Bob for whatever, right? But the key here is the defense. So your lawyer should say, well, there's a bunch of case law that says that his corporation is actually the entity that is responsible here, not him. Otherwise, why would you incorporate, right? So, but you are going to unfortunately have to spend probably a few dollars and go through a little bit of headache to get to that point where then you are resolved from liability. Yeah, it's not an ideal, it's not a perfect world, but yeah. Question?
Well, it appears the corporate veil certainly is very concerning.
Yeah.
And most of us have our home office in our home.
Yes.
So, and if people are gonna sue you individually and the corporation at the same time,
Right.
why bother to get incorporated?
Yeah. Well, that's a very legitimate question because of the way it's set up, because just the way the law is. The chances are still way better that your individual assets will not be touched if you have a corporation. You have an extra hurdle that a suing party has to go through.
Is
It's an extra
there
hurdle.
some due diligence that we as inspectors should do to try to demonstrate and prove that
Yes.
we are separating our
Yes.
business from our home?
Correct. So yes, and I'm glad you brought that point up. So what you should do then to give yourself the best shot at keeping that wall in place between you and your corporation, use separate email accounts, one for your business, one for your personal use, and don't intermingle them. Don't intermingle funds. That's a pretty clear one.
Don't intermingle what?
Funds. Money. Keep the two things separate. A lot of people work from home. I don't think it matters if you work from home. I work from home most of the time. You know, a lot of people do it now. So because it's so common, no worries there. But I would otherwise keep your papers, like I said, the paper trail, keep everything as distinct as possible in order to maintain that corporate shield for you. Okay?
And if we've gone for 17 years using our personal email account and
Don't stress
business.
about it now. Now you know better. Don't stress about it now. You're fine. I would say that's probably the smallest thing, like the least significant thing, really, because a lot of people do it too.
The government doesn't.
The government doesn't, that's a good point. So, but these are best practices to have in case the situation ever came, so you're protecting yourself as much as possible. All right, quick insurance talk, and then we'll get into some case studies. Those are really fun. They shouldn't call it insurance, they should call it in case stuff. Give a company my money in case stuff happens. Now, if stuff don't happen, shouldn't I get my money back? I love that.
That's not what Chris Rock said.
No, he didn't say that. I had to clean it up a bit. We're a family-friendly organization, aren't we? All right, so insurance, not required. Again, pros and cons. This is going to be up to you. So the pros gives you peace of mind going on about doing your job. It is a selling point to clients. I know some contracts do say that you have to have insurance in order to inspect a home, right? And it does. This actually is another layer to keep, even if you have that corporate entity, your insurance is going to kick in before it gets to your individual stuff anyway. So your assets are not going to be at risk if you have the insurance. Cons, obviously, it's so expensive, very expensive. And it also may make you more likely to get sued because they know you have insurance. They may just, the bad guys may try anyway just to see if there's anything they can get at. Jim.
Yeah, you're talking about E&O insurance.
Yes, I am. Talking about E&O insurance.
Everybody's got general liability.
Of course, yes. Thank you for clarifying that. Right, I'm talking about E&O insurance, yes. All right. Word about ethics. Ethics can also be, you guys already know, you know what they are. You know what the codes are, or the code of ethics. Okay. The reason I bring it up is because it could possibly be a basis for liability. If you don't follow the ethics rules, it could be a point where you could also find yourself liable to a client. All right, and here's this is the last slide before we get into the fun stuff. You would be surprised at how much the golden rule applies. Do unto others the way that you would want to be done to you. So if you say, sometimes, of course, I also have the caveat at the bottom, have a lawyer's number just in case. But yeah, you'd be surprised at how often if you say to a client, hey, I'm sorry that, I didn't do anything wrong, but I'm really sorry that you weren't happy with my report. What can we do to sit down and work it out? If you're just nice to somebody else, it diffuses the situation, they're less likely to get angry at you, and you have much better results. Yes, question?
You said earlier that most of the white line house and those guys signed the agreement.
Yes.
Of course, we don't know technically who's buying it.
That's
So,
true.
I bet no one in this room has both parties signed. But so if I, from here on out, just not in. Like, we just put the man's name aside, the report, and the woman's name, get him to sign it, I say.
Yeah, then you're. Yeah. You can say that?
One of the parties names off our report.
Put the name on the report you signed.
Yeah, the report, this is a situation where Betty at that point is a third party. So Betty uses the report to rely upon, or relies upon your report to purchase the house, then you're opening yourself up to liability against Betty still.
I have a clause in mind that says any party, spouse, or significant other will be bound by this agreement.
Now that's a good point you bring up. You can put a clause in your contract that says, that exact same thing. Or co-purchaser. Even.
What's that? We're gonna say,
Yes. Yes. The question was, what if Tom and Betty are married and I don't know, and they're both buying a house. And I just meet Tom. All my interactions are with Tom. He signs the inspection agreement, but he and Betty both buy the house, and then something happens down the road, and they say you didn't find something, and what happens then? Well, the answer is Betty at that point is a third party who relied on your report to buy the home. If they find something that they didn't like, Betty at that point does have standing to sue you, and she's not bound by anything in your contract because she didn't sign it. But you can fix that by putting a clause in your contract that says all co-purchasers, spouses will be also held bound by this contract. That will usually work. All right, let's get on to some of the fun stuff and we can talk about more issues here. Okay, so case study number 1. You answer a call from Tom who asks you to inspect a home he wants to buy. You set up an appointment and send him an electronic contract to sign before the inspection. He signs it electronically. It contains a limited liability provision saying that claims must be brought within 1 year. 13 months later, he sues you alleging that you purchased the home based on your findings and it's been a money pit. Tom's lawyer argues that the contract is unenforceable because Tom didn't actually sign the contract. He never received a copy of it and he wasn't aware of its terms. What if, this is actually a real case that came out March of last year. What, if any, is your liability here?
Prove that he signed it.
Any thoughts?
Prove that he received it and signed it through.
Prove that he received it and signed it. So you think that absolves you of liability? That's what you're saying?
I would think so, because I think electronic signing today is considered to be a legal acceptance.
Yeah,
of course, you're going to prove it's wrong.
Yeah.
I think that. This doesn't look good.
Yeah, you think that, right? What are your thoughts?
Is he going to suggest that there's no agreement, that you didn't do the work for him, that you had no obligation?
I think that's where the lawyer's going here.
Yeah.
The lawyer for Tom is going there.
So if he used any part of that home inspection, then he would be under the guidance of the agreement. I can't remember, because I have something worded like that. If you use any portion of this report, blah, 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 blah.
But Tom is saying that I didn't actually sign it. I don't know what his argument is. Maybe he just was pushing buttons on his computer. I don't know. And he didn't actually sign it. He never got a copy of it. He never read it. Didn't know what he was agreeing to. Bob?
Details of electronic sign. Can you tell us what this is?
I don't know exactly how your proprietary software works, but I know Adobe is the most common electronic signature piece software. And it is sometimes, or in a lot of situations, it is becoming generally accepted to digitally sign a contract. Especially Adobe is so widely used that it can be accepted in most situations. You still can't. I do a lot of wills and probate work. You can't electronically sign wills at all. Trust, no. Those are out of it. You have to be physically present to sign. So there are some documents that you still can't electronically sign.
What if we ask them to take their smartphone, sign the contract, and take a picture of it and send you the picture back?
You could do that. That works. I think that would work.
The software that they use to sign the agreement has got an agreement posted there for the world to see.
Yeah.
Does that help?
I would think so.
Okay.
Okay, this case, like I said, this is an actual case. This came out in March of last year. It's called Hughes versus the Cornerstone Inspection Group. And normally these arguments would be rock solid. Too bad, you're presumed, you signed electronically. Electronic signatures are pretty common now, so much that they can be enforceable. That would be my argument, which would normally, I think, be a winning argument. And if it's rock solid law, been around for years, accepted for years, that if you sign a contract, then you're deemed to have read it, whether you did or not. Too bad. You're presumed under the law to have read the contract and understood it, not just read it, but read it and understood it. So that seems like a pretty rock solid argument based on the precedent. The Court of Appeals in Georgia said, maybe, maybe not. What they did was they actually let the case, this was a case where the defendant was moving to dismiss the complaint, saying, look, because this is ridiculous, all the law says, like I just said, that if you electronically sign it, it's fine, that if, and then if you've done that, then you're presumed to have read it and understood it. And so they moved to dismiss the case. The court said, not so fast. There's a little bit of evidence here that maybe he didn't understand what he was signing. Maybe he actually didn't sign it. And so I'm letting the case go forward. So the case went forward. So liability was open. I assume that we don't know what happens to these cases once they're reported, and then we don't know what happens. It probably got settled out of court, if I had to guess. Hi.
Okay, well, I'm going to break my own rule here and speak up.
Okay.
You need to be aware, and I'm sure Kim knows this, but this goes back to the year 2000. President Bill Clinton, regardless of your political affiliation, signed a federal law in 2000 called the E-Signature Act.
Okay. Yes.
The E-Signature Act was passed by the United States Federal Congress in June of 2000, and it was to facilitate the use of electronic records and electronic signatures in interstate commerce for ensuring the validity and legal effects of contracts entered into electronically. Okay, now, let me advise folks here that if you haven't ever heard of an electronic inspection agreement, go out to the internet, type in inspection agreements online, okay? If you use HomeGauge, okay, HomeGauge will help you with this, but you can put a form out on your website that has all your legalese in there, and a form at the bottom, and at the bottom a button called I agree.
Yes.
Okay?
Right.
Now, I'm not an attorney.
Yeah.
I'm not even a legal wonk, okay? But I will stand up and defend that, till the cows come home.
Oh yeah, I would too.
If I'm wrong, let me know.
First of all, the federal law, you said it applies to interstate commerce. This is probably not going to be considered a transaction that takes place between interstate commerce, arguably. But it probably won't be deemed that. But still, also that, again, a lot of law has to do with what's the most common thing now. So I think there's a very, very strong argument to be made, and it already is a valid argument in a lot of other business situations, that if you sign a contract electronically, it's enforceable.
Okay, the E-Signature Act spelled out in the first section, section 101.A, that a contract or signature, quote, may not be denied legal effect, validity, or enforceability solely because it's electronic.
Yep.
Can I make a statement on that?
I know, so I kind of wish the Georgia Court of Appeals read that before they decided this case, because it seems like a slam dunk, right? That's Georgia for you. We march to beat our own drummer sometime. Yes. Go ahead.
Let me make a statement. I'm Cornerstone Inspection Group. That was my case.
Oh my goodness.
There were lots of issues. There were lots of problems with the plaintiff's case.
Yeah.
The lawsuit was first thrown out.
Okay.
There were several issues. It was beyond a year.
Yes, it was. Right.
He did not make formal notice of his claim.
Right.
And this third thing, the electronic signing, was his third excuse. It was thrown out,
of course,
and then he appealed. It was brought back but in my opinion, it was not because of the electronic
Okay.
signature.
Okay?
It was because of the other issues.
Yeah,
That
I mean, there
it
are
was
a lot
allowed
of
to
issues
go
here,
forward.
yeah.
You know,
Right.
but the electronic signature was enforceable.
Yeah.
There were issues of when it was signed and how it was, in relation to the claim and the inspection, so.
The Court of Appeals actually says, we found some evidence that a case can proceed. And normally it's, and I made notes in the margin, but it's not admissible evidence. None of this is actually valid arguments. So what, did it case settle?
Yeah, we arbitrated it.
You arbitrated it?
No, I'm sorry, we mediated.
Mediated it, perfect, and it's settled. Well, good.
And
I was flabbergasted. I just thought, this is crazy. This is crazy. These are very strong legal arguments. This case should have been thrown out from the get-go. But yeah, I was shocked. Well, good. I'm glad you heard.
So in your opinion then, are electronic signatures okay?
Yes, I think so. I think they're generally accepted now, and they are valid, yeah.
I'm a member of ASHI also, the National Association. They have a magazine, and they talked about how this guy, the inspector, did not sign the agreement. It was his agreement, but he didn't sign it.
Yeah.
And it was detrimental to him because he didn't sign it. So what I do now, guys, I have 2 copies at the inspection, and I give them that as a receipt, and I sign the bottom with my name. However, I just thought about it. I don't, when they're not there, or I don't send them a copy. So maybe I'll start sending them a copy. Say, thank you very much. Here's your receipt. You know.
Yeah.
And that'll be the signed copy of my agreement with them. So,
Good idea. You should, yeah.
So if you don't sign it,
Pardon?
if you're the inspector.
You need to sign it as well, so you can also be bound by the terms as well, yeah.
Yeah, could you say by signing this, the client or buyer agrees that the inspector agrees as well? Can you do something like that?
Yeah, that's a little weird.
I wouldn't recommend it. I wouldn't recommend it, no. I would still sign it yourself. You sign it first, and you bring something out, I guess. Can you do that with your software? I don't know how that, it's not that too.
Yeah.
All right, let's see. Okay, this is another payment, since failure to get paid is an issue that comes up a lot. Here's a case study about that. You show up at an inspection, the real estate agent, not the client, is there to greet you. Probably common occurrence, right? She says the client can't make it, and again, this is kind of old school, but she has the authority to sign the contract for it. She signs your inspection contract and says the client will mail you the fee, you perform the inspection, client never sends you the fee. So first of all, who's responsible for the payment?
Well, can I ask one question prior to that?
Sure.
Whose name are you going to put on that report?
Probably the client, right?
Well, who signed the inspection agreement?
2 different people, right? The agent signed the agreement, so now where do you?
You hold the report till you get paid.
That's right. What do you do? What would you suggest you do in that type of scenario?
Right. Before I answer your question, what I would do, let me get other thoughts. Anybody else have any other input here before I tell you what I think?
Could you put under the agent's signature as agent for and name the client?
Yes. You could do that. There are a couple things you can do. You could say, you can write in as or on behalf of client's name. Agent on behalf of client's name. That would work.
On the contract?
Yes. You could write that.
Well, if the client denies it.
If the client denies it, then you're going to have to argue and go back and forth. So it's not the cleanest thing to do. But it's something you can do.
So if you do that, if you put that on the contract, then whose name goes on the inspection report?
Who would you put on the inspection report?
Sorry?
Who would you put?
Well, that's not necessarily. Whoever signed the inspection agreement, that's who I would put on there.
So you would put the agent's name on the inspection report. Okay. So then you shift the responsibility to the agent. That's fine.
But now she may not be the one paying for the inspection.
Right.
So where do you go there? It's a triangle.
That's right. So where do you go? But she wasn't the one that, she said he's going to pay for it.
The person who's paying for it's name should be on the report. That's the person who's paying for it. I mean,
That's what I would recommend. I would recommend the person who's going to use it.
I get reports sometimes where it's a parent purchasing a house
For
a child,
Yeah. Right.
an adult child,
Sure.
obviously. And that's the person whose name goes on the report. And I could put on there on behalf of and whatever their child's name is.
Sure.
But in essence, the name of the person who's paying me for it is the person whose name goes on the report.
Yeah. My thought on this is you have two people that can be responsible for your payment. You can make an argument that the client is the person who received the benefit from your report, the knowledge of your report, therefore they shouldn't get that benefit without having to pay for it. There is a legal cause of action for that. So you could still go after the client for that, and I think you can also go after the agent too for signing. So you got two parties you can go after here. That answers the question. All right. Pardon?
If they never pay the inspection, you love for anything that's in the report?
That's a good question. The question is, if they never pay for the inspection, then what are your duties about the report? Are you liable for anything that's in the report?
No, they haven't lived up to their contract.
Breach contract.
Yeah. The answer is probably no. If they wanted to come back later, well, yeah, well, I'll pay you now, and I found all this stuff, and now I'm mad at you. That could happen.
Actually,
But in reality,
I don't think I'm giving them the report until they pay.
yeah, that's a very good practice. I think a lot of people probably do that nowadays, is you don't release a report until they paid you. Great. Leverage is all it's about in payment situations. Yes? What?
Are inspectors afforded any protection under the right to repair?
Question is, are inspectors afforded any protection under the Right to Repair Act?
In other words, if somebody has something fixed and they come back and say, you missed this, I want you to pay for it.
Okay.
I've already had it repaired.
In that case, no. You're not specifically covered under the right to repair, but you are covered under your contract and all this other stuff we talked about. So it's just a different mechanism, but same protections. Yeah.
What if you have that in your pre-inspection agreement?
Pardon?
What if you have that clause in your pre-inspection agreement that you have right to repair before?
Yeah.
Or a right to re-inspect, maybe?
Before repairs are performed or whatever.
Absolutely. You should. I think that's fantastic. You should do that. You should say that you have the more control you can give yourself, the better the outcome is going to be for you. All right. We have time for a couple more. Maybe one more. Okay. Paul and Joanne hire you for a home inspection. This is another case, an actual case. You have an entire agreement clause in your contract. Remember what that one is? That means that whatever is said outside the contract doesn't count. You inspect the home and use binoculars for the roof. They tell you they're uncomfortable with that, and they really want you to get up on the roof. You say that's just not your practice. They relent, and at the end of the inspection, you orally summarize your findings with them, saying that you saw nothing but normal wear and tear on the roof. Sorry for the typo there. A few months later, Paul and Joanne threaten to sue because they say you missed cracks on the gables on the roof and it will cost $27,000 to fix. What, if any, is your liability? Again, this is a real case.
What was the summarize? Is that in writing or verbal?
Verbal.
Limits liability.
You're limited to the cost of your inspection.
Limited to the cost of, if you have a limited liability clause, you're limited to the cost of the inspection.
But there's no liability because there's nothing in writing.
Okay? That's right, because all you said was normal, well, you said normal wear and tear on your report. But your contract, you have.
Wait a minute, you said it was not a report, it was just verbal.
You have, okay, so two different things. Maybe I should clarify. You have a contract, and they sign it. There's, in this scenario, this is, again, like I said, a real case. In this scenario, there's no question that there was a forcible contract before the, signed before the inspection began.
Right.
Okay. And there's an entire agreement clause which says oral representations are not, they're not valid. They're not enforceable.
Right.
So what happens is, you say, oh, I just see normal wear and tear on the roof. Okay? And you summarize it, you explain that to them. Oh, I saw some normal wear and tear. What I saw was this, this, this. And they say, okay, great. And everybody goes on about their merry way, and then it turns out they have to have something done on the roof, and they say, holy crap, there are a bunch of cracks on it was on the gables. Yeah. And they come after you saying, you should have seen that.
What does the report say?
Your report says normal wear and tear.
Wait a minute, was there a report or was it?
Yes, there's a
verbal?
report as well, but your report just says normal wear and tear.
That
But
just-
your oral representations are, maybe you gave a little bit, I think they gave a little bit more information, but
So the verbal was similar to what was in the written report?
yeah, maybe a little bit more information.
That's where you can
So-
say you need an access for review to hide it.
Okay, yeah. So what happened in this case, this was a much more reasonable outcome than your case, I think, and faster, is the entire agreement clause threw the case out. So anything you said, that coupled with the fact that there was a visual representation clause in your contract. This is a visual inspection only. You said, yeah, it just looks like normal wear and tear. That's all I can see. I'm looking at, and they know you're looking with binoculars, right? The home inspector was protected here because of the contract. Does the contract include an entire agreement clause? Does it include a visual inspection clause? So everything, in other words, if you think about it this way, your expectations, contracts are a lot about expectations. Your expectations were put forth upfront and very clearly, and it protected this guy from potentially set $27,000 worth of liability.
I'm sorry, I just want to get this question in.
Sure. One more question.
When we agree to inspect the house, I base my fee upon the type of construction,
Sure.
size of construction, et cetera. Or Zillow, whatever the metric that we use. Of course, the clients always say, well, it's just an easy, small house. 5 hours later, you're bragging out. I'm sure too. So how do you, and obviously the agreement is based upon the fee. How did, in your scope of services contract, where you list your fees, that may change. It often does.
That's a
when you're
good-
on site.
that's a good real-world question.
How do you legally kind of
Usually, legally speaking, if you quote your fee up front and you say it's a flat fee, you're bound to that no matter how long it takes you. You've just given them, however many hours of free inspection services. You end up bearing the brunt of that financial loss. But if you say in your contract, the fee may increase depending on the amount of work done, the scope of the work. Well, your scope should be the same in the contract. You should still just have one scope. But if it takes you longer than you thought, has this happened to anybody?
Sure. You get there, they don't tell you there's a crawl space, and there's a crawl space.
Okay.
The agents say, oh, we'll just take a...
It'll just take a minute. And you get there, and oh no. So obviously you're not looking to go. So what do you guys do?
If I go out there, there's a crawl space, I'll talk to the client, when I get there at the front, and I'll say, I wasn't told, I wasn't made aware.
Okay.
I'm going to have to charge you an additional fee.
Okay, so you just say orally, additional fee. But you're there on the site, so the client really kind of is like, okay, I guess so. Kind of bound.
No, it's up to him if he doesn't want to do it.
But if he
that's
doesn't
fine.
want, that's right. Then if he says, well, that's too
Okay.
much, then he can.
But I'm not going to put it in the law.
Okay, I think that makes sense. Good business practice.
Similar, and again, just outright lie that square footage of the property, I was inspect. You pull up and look, instead of a 3,000 square foot house, it was close to 6. And you call him up on the phone and say, fella, you told me this is a 3,000 square foot house. It's nowhere near that, it's close to 6. And I based my fee on what you shared on the phone.
Right.
Either we need to get this settled now, or I can't do it for this fee.
Perfect.
And the guy said, we're already there, just go ahead and inspect it. Well, the fee, I said, thank you, no, goodbye, you need to get another inspector. And I left.
Good for you. Good for you. That's a good business practice, I think.
But in that case, if you would have said, okay, I'm gonna pay you your fee, but you have an inspection agreement signed with another amount, then what happens? You don't look at that
That was
agreement?
my question.
Okay,
So
sorry, say that
you're
one more time.
addressing it and your client's not
He
there.
misrepresented.
Yeah.
Not always.
And fee. Okay, let me take this one question again. Say that one more time, and then we'll move on to the last
Following
thing.
the gentleman's case, that he goes to the inspection,
Okay?
and his fee is more
Right.
because of the square footage.
Yes.
The client had already sent him an agreement, and I assumed that it had an amount on it.
Yes.
So now that's not the
you do the inspection, so what do you
Yeah.
do, reschedule it, or?
All you need to do is one simple thing. You guys carry pen and paper around with you? Write 1 or 2 sentences saying, the house is, just documenting what's happened. You told me this, you know what I'm saying? You told me it was this, but you can say, more square footage on the house means we have to agree to a higher fee. Here's the fee. And then write it. Handwritten is fine. X line, you sign. X line, client signs. Then you go ahead and inspect. You can just, it's an addendum to the contract, and it's just as valid as the contract. Pardon? Yeah. Well, yeah.
So I would hope.
So, or you can leave.
Oh, that's mine, don't do mine.
One second. Uh-huh. Go ahead.
On my signature,
Is this thing on? Oh, yeah. All along? No.
Yes.
I think they're just trying to record it.
No, that's fine. That's fine. Question.
what about a misrepresentation?
A misrepresentation clause in your contract saying if the client misrepresents, that's perfectly fine. Say if the client misrepresents the condition or the size of the home, then the fee will increase at the inspector's discretion. So then when you get there, all you have to do to amend your contract is just put a little something in writing, have him sign it or her sign it, and you sign it, and then you're off on your merry way. You're just as protected as you were before. All right, I'm going to let you guys get to lunch. Before that, if you don't mind filling out the surveys, that would be fantastic. And just pass them to the right and not just collect them there. These are things that I can do for you. I give you business advice. I'm going to start a new membership program where you pay a small fee and you just can call me whenever you want. It's cheaper and more effective for solo practitioners. I work with a lot of solos. I can help you with business setup if you're not incorporated. Contract drafting and review, I do a lot of that for you guys. I do pre-litigation advice and negotiation. I don't do as much litigation as I used to, but I do take certain cases. I've worked with you guys for a long time. If you guys have an issue, I'm most likely to help you out. But I don't take every case that walks in the door anymore. I also do estate planning, so if you guys don't have wills and stuff, and you are a small business owner, it's important that you do have a plan in place in case something would happen to you tomorrow. You want to make sure that your business assets are going to be taken care of properly, your family's going to be taken care of properly. They can help you with that, and then probate stuff. Again, if you fill out the survey and you want to schedule a meeting with me to discuss anything that is pertinent to your business, you can come for free. If you fill out the survey and send it back, it's a $250 value, and that's how you reach it. Thank you guys so much for your time.
All right, we'd like